In this third and final installment on our three-part series on the branches of the federal government, we look at the role of the third and weakest branch. At least that's what our founding fathers thought. What is the role of the federal judiciary? What are the extent of its powers, and how do they relate to the other two branches of government? And why is a proper understanding of the role of the judiciary critical if the United States is to remain a constitutional republic? We'll answer this and other questions next, right here in the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. We teach, rise, and generation be free. We're returning the Constitution to its rightful owners, we the people. I'm glad you could join me today as we wrap up this third-part series. I say wrap up, but I've had several questions about content in the previous two episodes, so maybe I'll do another couple of episodes answering those questions. Now, I've got a lot of information. There's more information, of course, on the website, constitutionstudy.com, but I'll get to that later in the episode. For now, let's talk about the federal judiciary. Like many of you, I've watched courtroom dramas, read about federal court decisions, and drawn conclusions about how the courts work. Then I read the Constitution and learned just how wrong that education I had received was. Let's start with the creation of the federal judiciary. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. Just as the legislative branch was created in Article 1 and the executive in Article 2, the judicial branch is created in Article 3. Now, what is this judicial power that has been vested by this article? Well, from Webster's 1828 dictionary, we find the judiciary is that branch of government which is concerned in the trial and determination of controversies between parties and of criminal prosecutions, the system of courts of justice in a government. The role of the judiciary is twofold: the prosecution of crimes and the determination of controversies. While the prosecution of federal crimes does happen in the federal judiciary, most of the cases we see coming out of these courts have to do with controversies, disputes, or disagreements. That means, as I believe more than one Supreme Court nominee has stated, the role of the courts is primarily that of an umpire. Now picture this. A base runner is charging toward home plate. The catcher is standing over the plate, waiting to receive the throw from the outfield. In less than a second, the ball enters the catcher's mitt, and he immediately sweeps down to tag the runner, sliding into home plate with his arm outstretched to sweep across it. The base runner believes he is safe, while the catcher believes he tagged the runner out. We have a controversy. What we need is a disinterested third party, someone who knows the rules and can look at the evidence to decide the controversy. This is the role of the umpire. He knows the rules of the game. Things like the ball must be in the mitt to legally tag someone out, and that the base runner must physically touch home plate. The umpire also has access to the evidence and the memory of what he observed in the split-second interaction. Based on this information, he must decide if the runner is safe or out. Then the umpire will announce this decision with a grand gesture and a loud call. And to no one's surprise, the loser of the decision will immediately confront the umpire to appeal it, possibly even appealing to other judges to confirm their position. This is actually a very good analogy of how the federal judicial system should work. A person is charged with a crime or files a lawsuit for a redress of some grievance. The plaintiff, in the case of a suit, believes that he has been aggrieved and is looking for a court to agree with him, while the accused, called the defendant, believes they have done nothing wrong. In a criminal case, the prosecutor believes the laws of the government have been aggrieved by the defendant. Both sides come before a judge, someone who is supposed to be a neutral third party who's familiar with the law. Sometimes the judge will make the final decision. But in the case of a crime or some civil suits, the decision will actually be made by a jury, and the judge is there to make sure the two parties follow the law in the courtroom. The parties to the case present evidence and the law to show they are correct. Now, while a jury trial is a bit different, in a judicial trial, the judge makes his or her decision on the controversy. Often, one party will not be happy with the decision, sometimes leading them to appeal to a higher court, which explains the beginning of Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. See, the Constitution only creates a single court, a Supreme Court. Notice the S in supreme is not capitalized. That's because it's an adjective. It modifies the noun court. It wasn't until the formation of this court before it was given the name Supreme Court, a proper noun. Now, Congress creates all of the inferior courts, giving them the names district and circuit courts. There's another very important phrase in Section 1, and it's not that the judges get paid. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. We've been taught for so many years that federal judges have lifetime appointments. This lie has been repeated often enough that it's believed to be true, but federal judges only hold their offices during their good behavior. Who decides what good behavior is? Congress, through the impeachment process. Section 2 of Article 3 deals with the question of jurisdiction, or the limits within which the judicial power of the United States may be exercised. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to all cases affecting ambassadors and other public ministers and councils, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens or subjects. The federal court can only legally deal with cases that come up under the Constitution, laws, or treaties made by the United States, or cases involving foreign actors such as ambassadors or public ministers, where the United States is a party, or a controversy between the states. The controversies between a state and citizens of another state was changed with the 11th Amendment, which reads, "The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state." The federal courts are further broken down between their original and appellate jurisdictions. From Section 2 of Article 3, we see, "In all cases affecting ambassadors, other public ministers and councils, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as a Congress shall make." Cases involving ambassadors, public ministers, or where a state is a party to the case go directly to the Supreme Court since they have original jurisdiction. Now, all of the cases go to an inferior court first, but then can be appealed up to the Supreme Court. That is, unless Congress creates an exception or a regulation to that jurisdiction. Lastly, the Constitution deals with the type and location of trials. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where said crimes shall have been committed, but when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. With the sole exception of impeachment, federal criminal trials must be jury trials. Such trials are to be held in the state where the crime or crimes were committed, and if the crime did not occur in a state, Congress has the power to pass laws to determine where such a trial is to be held. Lastly, Article 3 deals with the question of treason. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act or on confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attained. The word treason is thrown around a lot lately. However, I remind people that within the United States, treason has a very specific definition: levying war or giving aid and comfort to the enemies of the United States. The word enemy is bandied about quite readily as well. Yet it too has a specific definition, not from the Constitution, but from the language of the time, where we find enemy is a foe, an adversary. A private enemy is one who hates another and wishes him injury, or attempts to do him injury or to gratify his own malice or ill will. A public enemy or foe is one who belongs to a nation or party at war with another. Now, since the United States is a public entity, then its enemies are public as well. That means enemies of the United States are those who belong to a nation or party at war with it. Now, Congress gets to decide the punishment for treason, but no punishment shall work corruption of blood, meaning the loss of the ability to inherit land, or to extend beyond the life of the convicted. In general, this language is to prevent the punishment of treason from extending to the family of the convicted. That's it. Those are all the powers delegated to the third branch of government. But there is one point that is passed into law that we need to deal with before we conclude. The Supreme Court is the last court of appeal, but that does not make their opinions the supreme law of the land. From Article 6, Clause 2, the Supremacy Clause, we read, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary, notwithstanding." See, the Supremacy Clause lists three things that are the supreme law of the land: the Constitution, the laws of the United States made following the Constitution, and treaties made under the authority of the United States, which is established by the Constitution. Notice what you don't see: the opinion of a court. Now, people may call them rulings, but they are nothing but opinions. They may even call them case law, but they are not law because, if you remember when we covered the role of Congress, all legislative or lawmaking power is vested in them, not the courts. Again, from Article 1, Section 1, we read, "All legislative power herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives." With all the impact the courts routinely have in our lives, why did I refer to them as the weakest branch of government in the introduction? Because they are, at least according to Alexander Hamilton in Federalist Paper 78. Whoever attentively considers the different departments of power must perceive that, in a government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be least in capacity to annoy or injure them. The executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or of the wealth of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. If, as Alexander Hamilton says, the courts have neither force nor will, only judgment, then why do many call their decisions rulings? I'm sure there are several theories behind that, but to me, the answer is the elevation of stare decisis over the law. The Free Legal Dictionary defines stare decisis as Latin for let the decision stand, the policy of courts to abide by or adhere to principles established by decisions in earlier cases. While often used interchangeably, stare decisis is different than precedent, which is defined as a court decision that is cited as an example or analogy to resolve similar questions of law in latter cases. The Anglo-American common law tradition is built on the doctrine of stare decisis, stand by decided matters, which directs a court to look to past decisions for guidance on how to decide a case before it. This means that the legal rules applied to a prior case with facts similar to those of the case now before a court should be applied to resolve the legal dispute. See, precedent is a simple matter of looking to past cases for guidance to help decide a case, whereas stare decisis is the idea that previous decisions should be abided by. The problem with stare decisis is it assumes previous decisions are both legal and correct. By following stare decisis, it has become very difficult, often turbulent, for a court to decide a case based on the actual law rather than the opinions of their predecessors. The elevation of stare decisis has also led to a form of Gnosticism within our legal system. From Merriam-Webster's online dictionary, we read that gnosis means esoteric knowledge of spiritual truth held by the ancient Gnostics to be essential to salvation. The idea of the Gnostics was that they had special knowledge of spiritual truth. The Gnostic ideas in our legal system today are that the judges have special knowledge of the law and that attorneys are there to walk your case through the vagaries of that special knowledge. That's why so many people believe they need an attorney to file a lawsuit or to defend themselves in a criminal case. The complications of the actual law make those actions difficult enough, but mix in the Gnostic knowledge of case law, and the legal field has created a barrier to entry for all but the most dedicated, thereby keeping everyday Americans ignorant of both the law and their rights. Now, how are we to approach this weakest branch of government? We start by reminding people that, with the exception of jury trials, the decision of a court is an opinion, nothing more. We must relearn what Alexander Hamilton taught us, that the courts control neither the purse nor the sword and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. Understanding this may help as we wade through the morass of political doublespeak that inundates us every day. The role of the courts is that of an umpire, making decisions based on the law using the facts presented to them. Today, we have elevated their decisions beyond law into rulings as if they were kings and queens on high. It'd be one thing if the decisions were based on the law rather than the rantings of their predecessors. Read a Supreme Court opinion and you'll rarely find the Constitution quoted. Even when it's referenced, it's almost always the quotation of an opinion of a previous court. We used to have courts of justice. Then we had courts of law. Today, we have courts of opinions. How can the United States be a republic if we are ruled not by the law, but by the opinions of 9 high priests in black robes? Well, there we have it, the third branch, and probably the most misunderstood branch of the federal government, the judiciary. The weakest branch that today seems to wield the most power. It's because you don't understand, because the knowledge has been hidden from us. We've been told, you can't understand it, it's too complicated. Except it's not. The Constitution was written so an 18th century farmer could understand it. Shouldn't a 21st century American be able to understand it as well? I not only think so, I know so. Because I did it. I read the Constitution. I never went to law school. I never studied the law. I was never interested in the law. But I read the Constitution and I learned. Then I learned how to apply that to others. Now, if that interests you, please check out the Patriots program, constitutionstudy.com/patriots. The first step is a boot camp. And in that boot camp, I actually give you tools to actually protect your rights. I give you examples from my own life where I defend my rights. And you can take this boot camp absolutely free. Once you've been through the boot camp, passed the test, and taken the pledge, you'll be invited to the Patriots program. This is a 3-track program designed to help you do whatever you want to do better. In other words, it's not meant to replace whatever entity or program or group you're already a part of. It's meant to help you and that group do your job better, promote your agenda better, convince other people better. There's an education track for people that really want to get deep into the Constitution. They'll work with me, and not only on studying, but developing curriculum to help others understand the Constitution. There's a committee of correspondence where we learn how to communicate with each other, how we can avoid the censorship and other things that restrict our communication. So we know what's going on. We can get the word out about some event happening locally. We can find out what's happening to our neighbors so that we can give advice, answer questions. More importantly, activate the Minutemen, the 3rd track. These are men and women who are prepared to defend the rights of themselves and others, whether it's by assisting in a court case or showing up at a press conference or simply being willing to defend individuals and groups as they defend their rights. You can find out more, as I said, on constitutionstudy.com/patriots. I hope you'll join me. This program, I believe, will help elevate the Constitution study to get more visibility so more people can join us so that we can do more work. I hope you like that idea. I hope you like it enough that you'll come back and join us here at the Constitution Study.
Love the neighbors and have a few good